Most people think that having a will means everything is taken care of, and that's certainly not the case. A lot of your assets actually bypass the will and have nothing to do with what your will says. What actually happens to your money, your house, and your kids when you pass away? And why do most estate plans fail? Welcome to Demystify, where we bring clarity to everyday financial decisions. Today, we're going to be talking about the fundamentals of estate planning and what you need to know to ensure that your estate plan is in good order. Estate planning is not just for wealthy people. It's ensuring that your wishes are met and that your loved ones do not have to make difficult decisions in a time that's already difficult enough. So let's start with the basics. What are the basic documents that every good estate plan should have? I really break it down into 5 categories. First, the will. That dictates what happens to your assets and who takes care of your dependent children should you pass away. Wills also name an executor, which is the individual that's actually going to implement the wishes that are within your will. Wills can also establish trusts, which we're certainly going to talk a little bit more about later. You also have a financial power of attorney. A financial power of attorney is someone that can transact financial decisions on your behalf. Now, the use case for this is that if you were to become incapacitated, someone would be able to call financial institutions on your behalf, pay your bills on your behalf. One thing that's important to note about this is, unless it specifically specifies otherwise, giving someone the power of attorney or naming someone your financial power of attorney allows them to transact on your behalf at any time, whether or not you're incapacitated. There is such a thing as a springing power of attorney, but that would only go into effect should you become incapacitated. I've heard mixed reviews from different attorneys about that. Some people like the springing power of attorney, some people don't. On paper, it sounds good. That's why you have it. You have it there in case you can't be making those decisions. The reason some people don't like it is because it adds an extra step in that process where you now have to be deemed incapacitated before that document goes into effect. You also have the medical power of attorney, which is very similar, but for medical decisions. And for those of you out there that are married, just because you're married doesn't necessarily mean your spouse would be able to make those decisions on your behalf. Doesn't mean they'd be able to inquire with the doctors or get medical records unless they have that document. Now, in practicality, most doctors will work with you on that. Most hospitals, healthcare facilities will work with you on that if you are the spouse, but they technically don't have to. Also, those of you that have kids out there, maybe they just turned 18 going off to college, you now no longer have say in what happens to them from a medical standpoint unless you have that medical power of attorney. So it's always really good practice. A great gift, and we say this jokingly, a great gift to give your college student as they're leaving is a medical power of attorney. So God forbid anything happens, you can be there and you can take care of it. You also have a living will. Living will is going to be more end-of-life circumstances, the kind of pull the plug clause, if you will. Once again, what you'll see throughout estate planning is that you are making the decisions so that 1, your wills are met, and 2, your family members don't have to make that decision. The living will is a great example of that. You're making the decision saying, hey, if I'm going to be on life support for the rest of my life, pull the plug. It's very difficult for family members in that time. It's an emotional time if you're in that state. So let's try to avoid them having to make the decisions and you make them for them. Lastly, we have trusts. Trusts are a great estate planning tool that can be used, and they're not necessarily just for the uber wealthy. That's a common misconception. People think trusts, that they're super fancy, that only uber wealthy people can use them, and that's not necessarily the case, and we're going to dive a little bit more into that later. As you can see, most people think that the will is the centerpiece, but the reality is it's just one piece of the puzzle, and there's a lot more that goes into estate planning than just the will. But let's dive a little bit deeper into the will. So what does the will actually do? You're probably sitting there thinking, well, all he's done so far is discount it and say that it's not as important as others may think, but it does certainly have its place. And I think for most people, the most important aspect of the will is if you have dependent children. Whenever I'm meeting with clients, one of the first things I ask if they have kids under the age of 18 is, do you have a will? And if they don't, I say, you need to get a will. It is very important that you have that because at the end of the day, who do you want making the decision about who takes care of your kids? Would you like to make that decision, or would you want the state that you reside in to be making that decision for you? Most people think it's the end all be all. If I pass away, everything goes to my will from an asset standpoint. The reality is there are a lot of assets that come out before they even get to the will. Let's talk about that a little bit more. So first, you have any assets that are held by joint registration. Now, I got to be careful there because I'm only talking about an asset held that is held jointly with right of survivorship. What that means is, say me and someone else own an asset together. If we have rights of survivorship and I pass away, it automatically goes to them. It does not matter what my will says. My will could say it all gets left to my brother, but if it's a jointly owned asset between my mother and I with rights of survivorship, it's going to her. Then you have assets with beneficiary designations, and this really is a catch-all for most people. This is going to be your retirement accounts, 401ks, IRAs. This will include pensions, annuities, life insurance. They're all going to have beneficiaries. Even a trust can have a beneficiary as well. So if there is an asset that you have that has a beneficiary designation, it does not matter what your will says. You could have a 401k through your employer. You could say in your will, I want my 401k to go to my brother. If the beneficiary on that 401k is your sister, it's going to your sister, not what the will says. When it comes down to it, the will only pertains to assets that are held in your name only that don't fit one of the other two criteria. So why do people try to avoid assets going to the will? And that's because of an administrative process called probate. So what happens with probate? Probate is just an administrative process where the executor of your will is going to have to take your will to the local courthouse and make sure that it's valid. The courthouse then validates the will, and it now gives the opportunity for creditors to come after the estate. So probate makes the will and any of the assets within the will public knowledge. So one of the reasons that people like to avoid probate is for privacy. They also like to avoid it because it's an administrative hassle. Some states are worse than others, but it's at the end of the day, it's an administrative hassle that if you can avoid it, it does help your beneficiaries and whoever you're leaving assets to in the long run. So what happens if you don't have a will and you pass away? Let's just talk about it from the asset standpoint. If you pass away without a will, you've considered to be passed away intestate. At that point, the state that you reside in is making the decision as to who takes care of your kids and what happens to your assets. And it's not always as cut and dry as you may think. Let's say you're looking at a family that married couple and they have a couple kids. If you pass away, it doesn't always mean that your spouse is going to be left those assets if you don't have a will. Some states have a different pecking order for how they actually get split up. Sometimes some will go to the spouse and some will go to the kids, and then the rest comes back to the spouse, but it's not as cut and dry as you may think. So let's dive a little bit more into trusts. And from a very broad standpoint, there are two types of trusts out there, an irrevocable trust and a revocable trust. We'll start with a revocable trust. Think of a revocable trust very much as an extension of yourself. If I create a revocable trust, once again, a trust is nothing more than just a piece of paper with rules on it. If I create the Nick DeVito revocable trust, I can put an asset in, I can take it out. The tax ID number of that trust is my social security number. I still retain ownership. I still have control over those assets. An irrevocable trust, on the other hand, it's self-explanatory. It's right in the name, irrevocable. If I create the Nick DeVito irrevocable trust, if I put an asset in there, it's not coming back out for me. It's now going to be dictated by the rules of the trust that I created. You're losing control of that asset, semi-losing control of that asset once it goes into that irrevocable trust. Now, there are certainly use cases for both. What I'll first talk about a little bit is the revocable trust. So why would someone use a revocable trust? A good use case for a revocable trust is to assign a beneficiary to an asset that otherwise wouldn't have it. For example, a house or a car. Most states don't allow you to add a beneficiary to a house. It's going to have to be dictated by your will, but if you don't want it to go to the will to avoid probate, the way to get around that is through the use of a revocable trust. So what would I do? I would create the revocable trust, put the house in the revocable trust, and now the revocable trust is assigning a beneficiary to that house. From an irrevocable trust standpoint, there are certain situations where it may make sense to fund it while you're living, but once again, you are losing control of that asset. You'll see high net worth individuals use irrevocable trusts to get assets outside of their state for tax benefits, but for most people, that doesn't come into play. Most people don't need complex trusts. Simple ones will oftentimes do, and there are definitely use cases depending on your circumstances. Let's dive a little bit into taxes. One area of financial planning that you will see bleed into pretty much every other area is going to be taxes. But today we're just going to be focusing on taxes surrounding estate planning. Let's first talk about the federal estate tax. It's currently 40%, and that applies to any of your assets within your estate over the $15 million federal exemption limit. What that means is any assets you have that exceed that 15 million get taxed at 40%. So if you pass away and your estate is worth $16 million, you're only paying, or your estate, because you're not alive anymore in this scenario, your estate is paying that 40% tax on that $1 million you went over. You also have a federal gift tax, which is also 40%. The way that works is everyone has an annual gift tax exclusion amount of $19,000. Now, that is $19,000 from you to any other individual. So I can gift my brother, my mom, my sister, my uncle. I can gift whoever I would like $19,000. And if I keep it under that limit per an individual, there is no gift tax. If I go above that $19,000 limit, I have two options. I can either pay the gift tax on anything above $19,000 that I gifted. So if I gifted $29,000, the first 19 would be gift tax free. The next 10 would be taxed at 40%. If I don't want to pay that 40% tax, I have the ability to kick that can down the road and take it off of my lifetime exemption limit of $15 million. Let's say I gifted someone $119,000 and I don't want to pay the 40% gift tax. The first 19 gift tax free, the next 100,000 I can elect to have that reduce my 15 million. So when I pass away, instead of having a $15 million exemption, I'm now at 14.9 million. And one thing to note there is you do have to file a form with your taxes to keep track of that if you're doing that. And with estate planning, it's very important to know the state-specific rules because it's all about where the individual passed away, not where the beneficiaries reside. So it's important to know your state's rules when it comes to inheritance tax or estate tax. Knowing your state rules is very important because the last thing anyone wants is surprises. And at the end of the day, with estate planning, that's really what you're trying to avoid is surprises and difficult decisions being made. So what are some mistakes that people make? We talked about it earlier, but people think that the will is the catch-all. Maybe they don't have the proper documents in place. Maybe their documents are old. It's always important to review and refresh your estate plan as your situation changes. The last thing you want is for your estate plan to not be aligned with your current life. What do I mean by that? Let's say you were divorced and get remarried. Well, if you never went and updated your will, if you never went and updated the beneficiaries on your various accounts, and you pass away, your new spouse might not be getting anything that you have, and your ex-spouse might be getting everything because you didn't review. A bad estate plan is just as bad as not having one at all. So really want to make sure that you have a good estate plan in place that you're reviewing on a routine basis. So why do you do all this estate planning? What's the point? It reduces stress for your family or whoever in a time that's already stressful enough. It can avoid infighting. The last thing you ever want is your passing to lead to fighting among family members, and I wouldn't be saying that if it doesn't happen. You want to be making those decisions. At the end of the day, estate planning is a way to protect your decisions and protect your family. Estate planning isn't about preparing for death. It's about protecting the people that you love. At the end of the day, estate planning isn't about the documents. It's about decisions. It's all about protecting the people that you love the most. If you found this video helpful today, I would really appreciate you dropping a like or subscribing to the channel. It really would mean the world to me. Thank you for joining me today.